Greetings. Today, for your consideration and amusement, I have not one, but two magic motions. Now please note that these are not magic motions in the sense that they will magically get me what I'm asking for from the court, but instead they are magic motions because they will kind of predict my future in a number of ways. This is because if the motions are granted, then I'll probably be getting fair trials on the two criminal charges I'm currently facing. But if the motions are not granted, then I probably won't be getting fair trials on the two criminal charges I'm currently facing. So at least I'll have an idea, one way or the other. The technical names for these two motions are inclusionary motion in limine and exclusionary motion in limine, which definitely sound like things that a magician or a wizard might say when they're casting a spell or performing some magic. So they have that going for them. And more seriously, at least as I understand it, as long as these types of motions are making reasonable requests and the prosecution doesn't object to them in writing, then they are supposed to be automatically granted by the court. All of which means that if the motions are not granted and I don't get what I'm asking for, then I should at the very least be provided with the prosecution's arguments and legal justifications explaining why they believe the motions shouldn't be granted and why I shouldn't get what I'm asking for. But then I might even get that if the motions are granted as well. And for reasons which I think will become fairly clear as I go over the motions, this information could be very useful at trial, or in case I have to appeal, or for the future 1983 lawsuits that I'll definitely be pursuing in the future. And obviously, I'm having some fun here. But I do take this situation and these charges very seriously. This is just my way of dealing with the absurdity. So, forgive me if necessary. Otherwise, hopefully this is more fun for you as well. Inclusionary motion in limine. Petitioner Sean Floyd, as defendant in case CR 24-789, moves to include his own 74-second-long audio-video recording of the events which led to his being summoned in this case as evidence at trial and for consequent consideration by a jury for the following reasons. The audio-video recording in question is publicly available online at that address, which is not on the copy on the screen. As matters of the court's own record, the court may take judicial notice of many of the following facts, and petitioner avers the remaining ones. Prior to his trial for a violation of conditions charge in 2019, petitioner had submitted recordings of two highly exculpatory telephone calls, one with a Waldo County deputy and one with a corrections officer, as evidence. At trial, petitioner was informed by his court-appointed attorney, Nathan Bell, that Bell had neglected to obtain an important exculpatory document or to get around to issuing a subpoena for the corrections officer mentioned above, who was a critical witness for the petitioner's defense. The prosecution, led by Assistant D.A. Entwistle, presented their case, and their witness, Deputy Moody, gave false testimony against the petitioner while under oath on the stand. Then, when it was time for the defense to present its case, Assistant District Attorney Entwistle moved to suppress the petitioner's recordings of the phone calls on the grounds that they constituted unsworn testimony as they were recorded subsequent to the petitioner's arrest, but prior to his trial. So in other words, what happened is I had asked for a certain witness, a critical witness, who would give evidence that was exculpatory, meaning it would vindicate me. And my attorney just didn't bother to, what he said, this is Nathan Bell, he told me the morning of my trial, He shows up and he tells me, just as the trial is about to start, that he drove by the jail that morning. This witness worked at the jail, was a corrections officer there. He drove by the jail and left a blank subpoena for this guy, this corrections officer, to fill out in case he showed up at work that day. That's what he did. That's what this defense attorney did regarding this trial. And it gets worse. They lied about stuff that the prosecution did. But I had a recording of this witness saying what was, what I needed to be said to exonerate me, that I had made sure was submitted. So even if this witness didn't show up, there was that which I had made sure that Bell had submitted into evidence. Then it was time for the defense to present its case. Assistant District Attorney Entwistle moved to suppress petitioner's recordings of the phone calls on the grounds that they constituted unsworn testimony, as they were recorded subsequent to the petitioner's arrest but prior to his trial. This was true of only one of the two calls, the less important one, but the judge would have granted the motion regardless, simply because Bell flatly refused to argue against it. He wouldn't even try. I remember he did this kind of Rodney Dangerfield thing where I asked, I said, we got to get this into, into consideration by the jury, at the trial here. Can't you do anything about this motion to suppress the evidence, which would be an exclusionary motion in limine, on the spot during the trial, I guess. And he did this. He goes, well, maybe he'll show up about the guy, about the corrections officer who didn't show up, of course. Eventually, however, Bell agreed to give the judge a note, which was written by the petitioner and which presented an argument against Entwistle's motion to suppress, which, didn't, take much. The assistant DA's motion was overruled. The calls were allowed as evidence. Deputy Moody was impeached as an obvious liar, and the jury exonerated the petitioner in very short order. But if the motion to suppress had been granted after all, the petitioner could very well have ended up being unjustly convicted of a crime he did not commit. And that was the plan. Presently, petitioner has very good reason to suspect that similar, unethical, Brady violation-like machinations may be underway in the case at issue herein as well. The relevant allegation is essentially that petitioner engaged in criminal mischief by damaging the alleged victim's motor trike without any just cause, out of the blue, unprovoked. Summoning Deputy Nichols' police report indicates that all of the available evidence, which comprises statements from Deputy Nichols himself, of course, as well as from the alleged victim, his wife, and an additional witness, as well as video surveillance footage from nearby Swan Lake grocery store, support this version of events. However, Deputy Nichols himself, of course, as well as the alleged victim, his wife, and the additional witness all lied, assuming Nichols is not also lying about the other's statements. Which he wasn't, because I now have those statements, or at least some of them. In particular, the stated facts are mostly accurate, but crucially, the order of events is reversed. In actual fact, the alleged victim, in this case, accosted, repeatedly threatened, and then essentially physically attacked the petitioner. He engaged in clear reckless conduct and very intentionally drove to endanger the petitioner out of the blue and unprovoked, and only then did petitioner react, and only defensively. This version of events is very clearly evidenced by the petitioner's own audio-video recording, i.e. this recording very clearly contradicts the statements by Nichols, as well as the alleged victims, his wife's, and the additional witnesses' as presented. Unfortunately, petitioner has attempted to submit this recording to Waldo County Sheriff's Department on several occasions. The Sheriff's Department, however, has so far declined to so much as acknowledge the existence of the evidence or to respond, comment, or communicate with the petitioner in any way regarding the case. In fact, Deputy Nichols goes so far as to falsely claim in his report that petitioner never even attempted to report anything regarding the incident. But he's a liar, and the petitioner has abundant evidence to the contrary. Given the Sheriff's Department's current and virtually unlawful recalcitrance, and Assistant DA Entwistle's demonstrable lack of ethical standards and current and virtually illegal refusal to share evidence with the defense, it's not unreasonable to suspect that the prosecution may be trying to unfairly and unlawfully suppress exculpatory evidence at petitioner's trial in the present matter as well. For the foregoing reasons, as well as in the obvious interests of the law, justice, and fairness, petitioner requests that the court grant his request to include his own audio-video recording of the events, as indicated above, as evidence at trial and for its consequent consideration by a jury. Signed, Floyd, 124-25, and it was sent to the DA's office on that same day. So they don't have very long to answer that. Assuming the judge doesn't just, cut them slack and deny it for some reason. But it seems pretty reasonable to me. I can't imagine why that would happen unless the judge is just very corrupt. Exclusionary motion in limine. Petitioner Sean Floyd, as the defendant in case CR 24708, moves to exclude evidence of his use of the phrase, quote, Belfast has victim-blaming criminal cunt police. If the Swanvillan gets no justice, Belfast gets no fucking peace, unquote, per se, or its material equivalent, from introduction by the prosecution as evidence at trial against the petitioner and its consequent consideration, in part or whole, by a jury as evidence of the petitioner's guilt for the following reasons. Firstly, the phrase comprises solely political speech, which, quote, offensive, unquote, or not, is protected under the First Amendment to the U.S. Constitution, as repeatedly upheld by the U.S. Supreme Court. As protected speech, use of such words cannot lawfully be criminalized. Second, use of this phrase does not constitute knowingly accosting, insulting, taunting, or challenging any person with offensive, derisive, or annoying words, or by gestures or other physical conduct that would in fact have a direct tendency to cause a violent response by an ordinary person in the situation of the person so accosted, insulted, taunted, or challenged, i.e., so-called fighting words, as per the relevant Maine statute, and in compliance with the above. Thirdly, petitioner avers that he sought and received very explicit confirmation from various officers at Belfast Police Department on multiple occasions that petitioners engaging in exactly and precisely such offensive political speech per se, both on protest signs and verbally, would not constitute a criminal offense, and despite open acknowledgement that such speech would likely be considered offensive to some members of the public. This includes unambiguous prior confirmation from former Belfast Police Chief McFadden, and more recently, and more than once, from current Sergeant Bell, both claiming to speak on behalf of the entire department, as well as from current Patrol Officer Littlefield, and even from the summoning officer herself, Megan Trebuzio, on more than one occasion, once explicitly and once tacitly. Evidence of all these interactions exists in audio-video format, much of it publicly available. Thus, the only reasons for the prosecution to introduce the petitioner's use of the phrase in question at trial would be to attempt to either prejudice or to confuse the jury. Its introduction could potentially prejudice its introduction could potentially prejudice the jury, against the petitioner by playing on people's more or less inherent shock at hearing certain words used publicly. Even those people who might not necessarily consciously object to such language, or who may even use such language themselves in private, say. The statute does not distinguish between public and private places, however. It essentially conflates them. Any interpretation applies to both contexts. Alternately, its introduction could be used to confuse the jury by seizing on the word, quote, offensive, unquote, which is in the statute, and essentially conflating the two meanings of the word in order to misconstrue and consequently misapply the statute. The New Oxford American Dictionary defines offensive two ways. One, causing someone to feel deeply hurt, upset, or angry, which is consistent with the commonly espoused notion that allowing freedom of speech must even include speech that many may find offensive. And two, acting aggressive, attacking, which is the meaning that is consistent with the U.S. Supreme Court's fighting words doctrine, as well as the relevant main statute. Please see the obviously willful misconstruing on display in the police report, which I already went over in a different video. If this motion is denied, the petitioner will require significant trial time to present a defense against this aspect of the charge. It takes a lot longer to debunk a false statement than it does to make such a statement in the first place. Moreover, anyone likely to read this motion probably has a fair amount of experience with the law in some fashion, and consequently will be able to apprehend the arguments contained herein in reasonably short order. However, it will take a lot longer to explain the relevant arguments and present the various supporting arguments, evidence, and testimony to a jury. It can be done, of course, but it will be a waste of the court's time and resources, and it will incur a further use of significant state and/or federal resources via future appeals and other legal actions if necessary. A 1983 suit is already almost inevitable. Moreover, especially given the fact that petitioner explicitly sought and received BPD's official and very express permission to use exactly such words while on public property multiple times, for the prosecution to now be permitted to turn around and force the petitioner to defend himself in court against an allegation, implication, or insinuation that the use of these exact same words, formerly expressly condoned by the police, now somehow constitutes or contributes to a violation of the law after all, would be egregiously unjust, outrageously unfair, nothing short of entrapment, and clearly a blatant violation of due process. For the foregoing reasons, petitioner requests that evidence of the petitioner's use of the particular phrase, quote, Belfast has victim-blaming criminal cunt police, the Swanvillan gets no justice, Belfast gets no fucking peace, per se, or its material equivalent, in part or whole, be excluded from introduction as use as evidence of guilt by the prosecution at trial. Signed by me and sent to the DA. Thank you very much for, excuse me, I've been inhaling a little bit of smoke in the making of this video. Smoke has been inhaled in the making of this video. Nothing illegal. Thank you for bearing witness to all that. An update, which I actually knew partway through making this video, my continuance has been denied by the judge. I don't know about these other two motions, but that's not necessarily a bad thing because I was asking for continuance of a minimum of 60 days for all these issues I was having, but if the cases were going to be dismissed, for example, let's go ahead and do that. Or maybe it's just that maybe the judge thinks 60 days is too long, maybe 30 days, maybe, who knows. It's not necessarily a bad thing, though, except that it's about 3 degrees out and I have to go catch my ride here in about 20 minutes, and then walk about 2 miles in freezing cold weather, and then find something to do until my 1 o'clock court appointment. So that's not great, but I will update you all soon. Thanks again. Keep fighting. Keep smoking if you do. Smoke 'em if you got 'em in peace.